Well, the central government today has made it extremely clear before a Supreme Court bench headed by Justice A.M. Khanwilkar that the ex gratia one-time proposal of granting an extra chance to the UPSC aspirants who exhausted their last attempt as on October 2020 to appear in civil service prelims is only for the candidates who have exhausted all their attempts and not for the age-barred candidates. Senior Advocate Chandru Singh, appearing for one of the interveners, submitted that if this proposal by the central government is accepted as it is, then all the students belonging to the scheduled caste, scheduled tribes, and the handicapped community will be excluded from this benefit because they have unlimited attempts, but the age bar is of 37. Similarly, a senior advocate Sham Devan and P.S. Narasimha also argued on the similar point and urged the central government to consider granting this extra attempt for the age-barred candidates also. Senior Advocate Devan even went to the extent of showing figures and stating that in 2011, when such relaxation was granted and students were permitted to appear for another exam in 2015, then those students were then 34 years old and the benefit was granted about 4 years later. So in this case, also with the extraordinary circumstance in mind of COVID-19, a similar relief could be granted. The Supreme Court also urged the central government to consider making a one-time exception. However, the central government as of now remains firm on the point of not granting an extra attempt to the age-barred candidates. Well, the Supreme Court today heard a petition by the Uttar Pradesh government seeking the transfer of Uttar Pradesh MLA Mukhtar Ansari from Ropar jail in Punjab to Ghazipur jail in Uttar Pradesh. Well, Solicitor General Tushar Mehta, appearing for the state of Uttar Pradesh, has submitted that the Punjab government was here vociferously defending a dreaded gangster. He also went to the extent of saying that a frivolous case was lodged against Ansari in Punjab, for which no bail was filed by Ansari, and that he was enjoying 5-star accommodation in Ropar jail, and that he should be brought back to Uttar Pradesh since there are serious criminal charges against Ansari, and the trial for the same is pending since he is there in Punjab. However, Senior Advocate Dushyant Dave, in one of the statements before the bench, said that there was no urgency in this case to be heard, to which a Solicitor General Tushar Mehta said that the bench should record the Punjab government's stand that there is no urgency in the case. The case would be again taken up shortly. Well, in one of the rare occurrences, the Chief Justice of India today said that it had issued notice in a petition by mistake, and that it would not shy away from accepting its own mistake, and that it should not have issued notice on the said petition. Well, the Supreme Court bench led by Chief Justice of India was hearing a petition seeking probe and investigation into biggest franchisee scam of India. Well, the CJI-led bench today also heard a petition by a Supreme Court advocate C.R. Jayasukin calling for a precedence rule to be imposed in accordance with Article 356 of the Indian Constitution in the state of Uttar Pradesh, citing the increase in arbitrary killings, police torture and custodial violence. However, the Chief Justice of India, S.A. Bobre, sought to know from the petitioner as to how many states did he actually study before filing that petition in the Supreme Court. To this, the petitioner went on to cite NCRB data and said that UP was the state which had ranked the highest in all these parameters of whether it be police custodial torture or custodial violence or arbitrary killings. To this, the Supreme Court said that either the petitioner withdraws his petition or that a heavy cost would be imposed on Jayasukin. The Chief Justice also went to the extent of observing that the lawyer in this case was not an affected party, and that a plea under Article 32 of the Constitution, which only calls for a plea in the Supreme Court when your fundamental rights are infringed, was not lying. Hence, the matter was dismissed. Well, that's all from Supreme Court today. Do stay tuned with Supreme Court Today tomorrow as well. And don't forget to like and share barandbench.com.